We are students from Tutorial 4, Group 2. Our group members are Vian, Chloe, Xiangqi, and Brian. Below are the details of our group's presentation. Our topic is freedom of speech in Malaysia. Now, let us look into the concept of freedom of speech. What does freedom of speech mean? According to Emeritus Professor Dr. Faruqi, it is part of a personal satisfaction, as it allows people to express their thoughts and idea without the interference and restraint of the government. People have the right to express and share their idea, feelings, and opinion through different platforms. Examples include printed media, TV or radio broadcasts, and social media. This is enshrined in Article 19 of the Universal Declaration of Human Rights. In Malaysia, every citizen has the right to freedom of speech, right to peacefully assemble, and right to form associations as provided for in Article 10 of the Federal Constitution. Why is freedom of speech important? It encourages healthy discourse and debate, as different opinions can help to prove or disprove assertions in all fields. It allows citizens the freedom to criticize the government and to hold them accountable for their policies and actions. It also encourages open communication free from restrictions or censorship. Furthermore, the governments can actually restrict the freedom of speech in order to protect legitimate state interests. In Malaysia, one key law used to regulate online expression is the Communications and Multimedia Act 1998, CMA. It's often invoked by authorities to take action against social media posts deemed offensive or harmful. Now let's look at what is it about. Section 233 of the Communications and Multimedia Act, CMA, governs online communication. Often seen as controversial, this law regulates the use of digital platforms like social media and messaging apps to prevent misuse and abuse. However, it also impacts freedom of expression, raising debates on its strictness versus online safety. Section 233 criminalizes harmful messages sent online with intent to annoy, abuse, threaten, or harass others across digital platforms. Section 233(1)(a) makes it illegal to purposely send offensive or false online messages to upset, threaten, or harm someone. Intention and content matter. Section 233 imposes fines up to 50,000 ringgit, jail up to 1 year or both, plus 1,000 ringgit daily for continuing offenses after conviction. This law applies to some cases like sending threats via WhatsApp, posting harmful content on Facebook or Twitter, or sharing offensive images. Offenders may face police action, fines, jail, or both, depending on the severity. Section 233 aims to protect against online harm, but critics say it is used to silence political speech. Human rights groups urge fair review to ensure protection without limiting freedom of expression in Malaysia. Now, let us look into some cases to see how the Communications and Multimedia Act, CMA, serves as a legal limitation on freedom of speech. Now, let's look at the case of Muhammad Fahmi Reza bin Muhammad Zarin v Pendakwa Raya, 2027 MLJ 399. Muhammad Fahmi Reza, a well-known activist and graphic designer, posted a satirical image in 2016 showing the then Prime Minister, Najib Razak, as a clown. Later, he uploaded a parody that looked like an official notice from the Malaysian Communications and Multimedia Commission, MCMC. In this parody, he included the censored clown image to criticize internet censorship. As a result, Fahmi was charged under Section 233(1) of the CMA, which makes it an offense to post online content that is offensive and intended to annoy, abuse, threaten, or harass. The first issue was whether Fahmi's satirical post could be lawfully restricted under Section 233(1)(a) of the CMA, particularly whether the content was offensive in nature and intended to annoy. The decision for the first issue was the court ruled that both elements under Section 233(1)(a) of the CMA were proven beyond reasonable doubt. First, the post was considered offensive, as it mocked and insulted public authorities, especially the police, PDRM, and the Malaysian Communications and Multimedia Commission, MCMC. Second, the court found that the intent to annoy could be seen from the design and tone of the post, which were clearly meant to provoke and criticize the authorities' censorship actions. The court rejected Fahmi's argument that his post was just a parody or political satire, stating that even satirical or creative expression can still be covered by the law if it fits the legal requirements. The ratio decidendi for the first issue was the court confirmed that Section 233(1)(a) of the CMA makes it a crime to post any communication that is offensive in nature and made with the intent to annoy, abuse, threaten, or harass. Referring to the case of Ong Eng Guan v. PP 1956, the court emphasized that the key element is intention. What matters is whether the accused meant to cause annoyance, not whether someone felt annoyed. As such, the court applied the law strictly and based on its wording, even if the post was satirical or political in nature. The second issue was whether the restriction imposed by Section 233(1)(a) of the CMA on Fahmi's satirical post was constitutionally valid under Article 10(2)(a) of the FC. which permits limitations on free speech in the interest of public order or morality. The decision for the second issue was the court decided that limiting his speech was allowed under Article 10(2)(a) of the FC, as it helped protect public order and morality. Fahmi Reza was sentenced to 1 month in jail and fined Rm30,000 by the Sessions Court. The ratio decidendi for the second issue was this case shows that freedom of expression in Malaysia is not absolute, especially when a statement crosses the legal limit set by the law. The second case is Nur Hisham bin Osman v Pendakwa Raya, 2010 MLGU 1249. In December 2009, Nur Hisham bin Osman was charged under Section 233(1)(a) of the CMA for posting an offensive comment online, Dalit Tuanku, Jilat Take Kit, that directed at the Sultan of Perak. The comment appeared on a webpage linked to the official website of the Sultan's office and was alleged to have been made with the intent to cause offense. Nur Hisham filed an application to quash the charge, contending that Section 233(1)(a) of the CMA was unconstitutional as it violated his right to freedom of speech under Article 10(1)(a) of the FC. The first issue was whether Section 233(1)(a) of the CMA violates the constitutional right to freedom of speech under Article 10 of the FC. The decision for the first issue was the court also affirmed that Nur Hisham was properly charged under the law and is liable to the penalties prescribed in Section 233(3) of the CMA. This includes a fine of up to Rm50,000, imprisonment for up to 1 year or both, as well as an additional fine of Rm1,000 for each day the offense continues after conviction. The ratio decidendi for the first issue was the court found that Nur Hisham's comment to be vulgar and offensive, not protected as satire or political expression. Accordingly, Section 233(1)(a) of the CMA was held to be a reasonable and constitutional restriction intended to promote responsible use of speech and communication platforms. The second issue was whether the accused online comment constitutes an offense under Section 233(1)(a) of the CMA. The decision for the second issue was the court dismissed Nur Hisham's application and upheld the constitutionality of Section 233(1)(a) of the CMA. It ruled that this provision constitutes a valid restriction under Article 10(2)(a) of the FC, which allows Parliament to impose limits on freedom of speech in the interest of public order and morality. The ratio decidendi for the second issue was the court affirmed that freedom of speech under Article 10(1)(a) of the FC is not absolute and is subject to limitations under Article 10(2)(a) of the FC. By referring to Sivarasa Razia v Badan Peguam Malaysia, the court emphasized that fundamental liberties should be interpreted broadly, but any restriction must be necessary and proportionate. The third case is Ahmad Abd Jalil v Pendakwa Raya, 2015 5 CLJ. Ahmad Abd Jalil, who aged 28, was charged under Section 233(1)(a) of the CMA for posting false and insulting comments on Facebook under the alias Zul Yahya. These posts were made to target the Sultan of Johor on October 10, 2012, from his office in Wangsa Maju, Kuala Lumpur. Despite the defense's witnesses and documentary evidence, the court found the prosecution's evidence, including digital forensic reports, credible and sufficient to prove guilt beyond reasonable doubt. The first issue was whether Ahmad's Facebook posts constituted offensive communication under Section 233 of the CMA. The decision for the first issue was the Sessions Court found Ahmad guilty under Section 233 of the CMA for offensive communication and imposed a fine of Rm20,000. The court upheld the conviction, rejecting the defense evidence as unreliable. It ruled that Ahmad's posts constituted offensive communication within the scope of Section 233 of the CMA, which lawfully restricts speech that insults respected public institutions in order to preserve public order and respect. The ratio decidendi for the first issue was the court held that communications insulting or degrading respected public institutions or individuals, such as the Sultan, may be lawfully restricted under Section 233 of the CMA to maintain public order and respect. Parliament's authority to criminalize such speech serves to prevent harm to societal harmony. The court concluded that Ahmad's posts fell within the scope and emphasized that online speech is subject to legal scrutiny when it poses a threat to social stability or undermines public respect for established authorities. The second issue was whether the application of this provision amounts to a lawful restriction of his constitutional right to freedom of speech under Article 10(1)(a) of the FC. The decision for the second issue was the court ruled that Section 233 of the CMA lawfully restricts speech that insults respected public institutions in order to preserve public order and respect. By doing so, the court implicitly upheld the constitutionality of Section 233 as a valid restriction under Article 10(2)(a) of the Federal Constitution. The ratio decidendi for the second issue was the court held that communications insulting or degrading respected public institutions or individuals, such as the Sultan, may be lawfully restricted under Section 233 of the CMA to maintain public order and respect. Parliament's authority to criminalize such speech serves to prevent harm to societal harmony. Now, let us look into the challenges to Malaysia's legal limitations on free speech. In Malaysia, the freedom of speech is guaranteed by the Constitution. It is clearly stated in Article 10 Clause 1 Para A, which provide that every citizen has the right to freedom of speech and expression. However, this freedom is granted with restrictions. To maintain the national security and social harmony, the government has established laws to regulate such freedom.
We have to regulate such freedom.
Agree.
These laws have also caused a lot of controversy and face challenges in practical implementation. The very first challenge is that the laws has been criticized for its vague and overly broad definitions. For example, Ali, a law student, is reading the Sedition Act 1948. He understands that a speech that contains a seditious tendency, such as inciting hatred or contempt for the monarchy or government, would be criminalized. However, he found out that the term hatred and contempt were not defined, so he searched online. This situation allows those authorities to interpret the law broadly and use it to target critics and human rights defenders, even in the absence of any real threat or incitement to violence. According to the International Commission of Jurists, ICJ, sedition is a strict liability crime in Malaysia, and even if the speaker did not mean harm,
I think the government should listen more to the people.
He may still be charged. To further illustrate, even if someone merely posts humorous, non-malicious memes online, they can still be investigated if the authorities believe the content incites hatred or contempt towards the government. In the case of public prosecutor against Azmi bin Sharam, the defendant was charged with Sedition Act for remarks he made in an online news article. Shalom challenged the constitutionality of the Sedition Act in court as it is from the colonial times. However, the court ruled that the law was constitutional. Political analyst Khoo K. Pung believes the ruling will undermine the credibility of the country's reforms. It will allow the government to use the law to restrict the freedom of speech of the political opposition. The next challenge is the criticism around the world. Other former British colonies similarly adopted the Sedition Act, but many have since overturned or repealed them because they were vague and outdated. For instance, Singapore in 2022 repealed its sedition law. Their Ministry of Home Affairs noting that some types of conduct covered by the Sedition Act should not be criminalized in today's context. During the 30th session of the UN Human Rights Council, the UN High Commissioner for Human Rights expressed disappointment with the Malaysian government's decision to expand the scope of the Sedition Act and introduce harsher penalties. Also, there have been repeated calls for Malaysia to align its domestic legislation with the International Covenant on Civil and Political Rights, ICCPR. Thank you very much for watching.